Hello. Welcome to today's program titled, What Now? COVID-19 Vaccination's Ever-Shifting Compliance Landscape. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the text box on your screen. For those of you interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down. It will not be reread, and it is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the webinar. At this time, I would like to turn it over to Scott Hecker. Scott, you may begin.
Thank you. I appreciate it. Welcome, and thank you everybody for attending today's Seyfarth webinar, What Now? COVID-19 Vaccination's Ever-Shifting Compliance Landscape. I'm Scott Hecker, a senior counsel in our DC office, and I've been counseling clients on COVID issues since my first day at the firm, which I joined from my basement office in March of 2020. I'm honored to be joined today by some of the firm's foremost subject matter experts on COVID-19 and specifically the federal vaccine mandates relating to the virus. All are members of Seyfarth's vaccine task force and have been at the forefront of addressing employer concerns and compliance throughout the pandemic. Tracy Billows, an L&E partner and co-chair of Seyfarth's Chicago office, serves as COVID counsel to the firm and is a leader and trailblazer in the legal profession. Adam Young is also a Chicago L&E partner situated in our workplace safety and environmental practice group. He concentrates his practice on the defense of Osha inspections and citations, so we'll have great practical advice for employers pursuing COVID compliance moving forward. And Adam Lasky completes our coast-to-coast coverage today. He's located in Seattle and serves as co-chair of our government contracts practice group. So he'll have insights into the current state of the federal contractor COVID-19 vaccine mandate. And we'll start with an overview. If we go to the next slide, Kate, we'll start with an overview, just walking through the agenda here, of the legal status of Osha's COVID-19 vaccination and testing ETS, as well as the CMS vaccine mandate regulation applicable to healthcare facilities receiving Medicare and Medicaid. I'll talk about that, and then Adam Young will address what we can expect now from Osha, given the status of the ETS. Tracy will take us through the CMS and current state and local approaches to COVID vaccination. Then to close out, Adam Lasky will address litigation surrounding the federal contractor mandate and what federal contractors should be doing now regarding COVID compliance in the face of various court stays. If we could go to the next slide, Kate. We'll talk about the stay of the ETS. It's been a long and winding road, and we've landed on January 13th in the Supreme Court with a stay of Osha's enforcement of its COVID-19 vaccination and testing ETS. The Supreme Court opined applicants are likely to succeed on the merits of their claim that the Secretary lacked authority to impose the mandate. So Osha, as of January 13th, when the restay happened, could no longer enforce its ETS, and it actually decided on January 25th to withdraw the ETS. However, at that time, Osha explicitly stated that the ETS remains as a proposed rule for a permanent standard. Osha ETSs, when they issue, become immediately effective and also serve as proposed rules for a permanent rulemaking under the Osha Act. Many of you, I'm sure, have read the opinion the Supreme Court issued. It felt that Congress did not speak clearly enough on an issue of vast political and economic significance, not using the majority not using the term major question doctrine, but the concurrence by Justice Gorsuch referring specifically to that canon. And we are in a place where the court felt that OSHA's granted authority was not as broad as the ETS, noting that it's the Occupational Safety and Health Administration and needs to tie hazards that it regulates to the workplace. COVID, more of a public health issue, traditionally the purview of states and localities. As we noted there, the permanent rulemaking continues, at least according to Osha for now. On the 25th of January, the government also filed a motion to dismiss proceedings, the merits proceedings before the U.S. Court of Appeals for the Sixth Circuit. And we'll have to see whether petitioners may push back on that motion to dismiss. The government argues the petitions are now moot based on its withdrawal of the standard. But you'll see, as we said there, it's more of a partial withdrawal because OSHA has let stand the statutory portion of the ETS that serves as a proposed rule. When 27 attorneys general filed a comment to the rulemaking on January 19th, they asked for a withdrawal of the ETS as well as suspension of the rulemaking. So we could see the petitioners move there in response to the motion to dismiss, saying this isn't enough. We need to see a full withdrawal. And Kate, if we could go to the next slide. We're just going to briefly talk about we saw here that the employers are not impacted in implementing their own mandates under the Supreme Court's decision. This is about OSHA's ability to issue and enforce that rule. So we'll have more practical advice from Adam Young going forward, but employers will need to consider the right fit for their workplaces and workforces in deciding whether to move forward with their own vaccine mandates or testing mandates. And we did hear also from Secretary of Labor Marty Walsh immediately after the Supreme Court's decision, expressing disappointment and advising that regardless of the ultimate outcome of these proceedings, OSHA will do everything in its existing authority to hold businesses accountable for protecting workers. And again, Adam Young will dive into what avenues OSHA has remaining available to it in the COVID-19 enforcement space. Next slide, please, Kate. And finally, real quick, I wanted to talk to you a little bit about the status of the CMS Reg. There was a companion opinion issued. Again, both of the CMS and ETS were argued before the Supreme Court on January 7th, and companion opinions were issued on the afternoon of January 13th. While the ETS was restayed, the CMS regulation was allowed to move forward. And the way we got there was an initial district court injunction from Missouri, followed promptly by one from the Western District of Louisiana. The Fifth Circuit narrowed the Louisiana injunction to 14 states, which meant there were 24 states under those two injunctions that could not move forward with the CMS. Then Texas actually had its own, making it the 25th. Now, after the Supreme Court opinion on the 13th, 24 of those moved forward. Texas was still an outlier for a second or two, but it's been withdrawn as well. And so now the CMS is moving forward in all 50 states. Tracy will talk to us about how that's playing out with compliance deadlines, as 25 states had this thing going forward, and those proceedings were never before the Supreme Court, never stayed. So we'll get to nuts and bolts compliance in that portion. For now, though, I'd like to push the next slide and turn it over to Adam Young to talk about what's next from OSHA.
All right. Well, thank you very much, Scott. I appreciate that. And good afternoon, everyone. My name is Adam Young, and I am a partner with the Workplace Safety Group here in Chicago. We've been helping employers throughout this pandemic understand what the law is, what the guidance is, and what their options are, both for protecting the health and safety of employees and then also for compliance with OSHA. It's not news to anyone that the Omicron surge is still going across the United States. And while the legal landscape has shifted with the ETS and what Scott described from the Supreme Court, there are still significant legal liabilities out there for employers who have workplaces where employees are coming in and interacting with each other and with visitors, and COVID-19 isn't being addressed with programs and with precautions. Biden ran his 2020 campaign on the ability to address the pandemic and use those government tools that are available. A primary administration goal was to get as many Americans vaccinated as possible. And they saw, doing that through employers and through OSHA as one way that they could try to do that. The ETS came up short in the courts, but of course the administration realized that that was probably a possibility when they issued it. It's a new, they knew that employers with 100 or more employees having to comply with that ETS may consider and push vaccination policies, even if the compliance dates are never reached. There's federal OSHA, there's also 21 state plans, and those state plans are state agencies that enforce the OSHA standards as to private employers in those states. And the states have the opportunity to issue their own emergency temporary standards. For the most part, they haven't done so. Minnesota adopted and then rescinded the federal ETS after the Supreme Court ruling. No other state has adopted it as of now. Tracy will talk a little bit more about the state landscape, but from a strictly OSHA perspective, we haven't seen state emergency temporary standards yet. The federal emergency temporary standard was a set of emergency regulations, but it was also a proposed rule to be considered in the rulemaking process, and it still functions as that. It's a very slow process in which OSHA could try to push the emergency temporary standard as a final rule and make it a permanent standard and rule going forward. The last major standard that they adopted, the walking working surfaces standard, took about 10 years, I believe, to get through. So it's a very slow and painstaking process, and it would be a really sui generis, contentious process as well, with all of the political discussion around infectious disease policy and public health. We would anticipate that there would be a very contested and contentious process. There has been some discussion about a broader infectious disease standard, maybe along the lines of the aerosol transmissible diseases standard that's out in California and applies to healthcare employers. So it's possible OSHA may go that route. The ETS seems mostly dead, but it could, resurface in other forms and new regulations in the future. All right, why don't we go on to the next slide? All right, so OSHA has a general duty clause, and it's a pour-over portion of its statute. It requires employers to provide a workplace that's free from any recognized hazard that could cause, likely result in substantial injury or death to an employee. It has to be a hazard, it has to be recognized, right? So is COVID a recognized hazard by the employer or in the industry? That would be the question. If there is a hazard, the employer is required to abate that hazard. OSHA has issued guidance on its website that it's updated with some regularity with regard to COVID-19. If employers look at that guidance, comply with that guidance, OSHA would be very in a tough place to show that there's been a violation of the general duty clause despite the employer complying with all of OSHA's guidance that's out there. So it's something to consider, that guidance. It's based on CDC guidance and NIOSH guidance that's out there as well. So throughout the pandemic, we've been recommending to employers that they track guidances from their state and local officials as well as from the CDC. And so long as you're following that, you're at much less liability in terms of the potential for OSHA citations. But OSHA has been getting complaints, and to the tunes of tens of thousands of complaints since the pandemic began, related to masking, relating to distancing, relating to hygiene, all the different tools that would be part of a COVID program. And each time they get one of those complaints, they send a letter to the employer outlining the complaint that's been made. A lot of times they open inspections against those employers. They also have a national emphasis program related to COVID-19. So what the agency says, we're going to devote a certain percentage of our resources to COVID-19 inspections and protecting employees from COVID-19 hazards. And through that national emphasis program, they've opened many inspections that target specific industries: healthcare, meat processing, warehousing, and certain types of retail. They're targeting for certain programmed inspections. So they'll essentially pull a name out of a hat in one of those industries, be it warehousing or meat processing, and they'll show up and do an inspection for COVID-19. So we have seen those types of inspections, and many of these inspections have resulted in citations. Those citations are civil penalties, and they have a monetary component as well. So we've seen multiple serious citations related to the same employer for COVID-19 inspection. We've even seen willful citations related to COVID-19 protocols, relating to respiratory protection in a healthcare setting, relating to masking in a retail setting. Osha has come in and issued clients willful citations. With regard to the respiratory protection standard, Osha has largely targeted healthcare and nursing homes with citations and inspections relating to that. Osha has this standard. It requires respirators to be used for employees who work in hazardous atmospheres. So, for example, if you work somewhere that you know people have COVID or are coughing or symptomatic, Osha may take the position that that employee needs to be wearing a respirator. Anyone who is assigned to wear a respirator, and that includes those N95s or those KN95s, those would need to be part of a written respiratory protection program. And that includes fit tests and medical evaluations and the whole 9 yards. So we've seen a lot of citations there. Those are things to keep in mind. If you are doing on-site testing for symptomatic employees, OSHA may see that as willingly exposing employees to a hazardous atmosphere. If you're requiring or saying anyone who returns from work after 5 days has to wear an N95, that would be mandating a respirator, and you need to have that part of the written respiratory protection program. So those are the bases we're going to see OSHA enforcing the respiratory protection standard going forward. Keeping violations related to COVID-19, and those are failing to record COVID illnesses through OSHA 300 log and failing to report fatalities to OSHA when they occur. OSHA requires employers to evaluate whether COVID illnesses were work-related. Do you know whether this person clearly got COVID at work? And if they did, it should be potentially recordable and reportable. Almost always the answer is we don't know. It is not clear where someone got COVID-19. If they're not living at that work site, they're going out, they're seeing their family, they're going to the grocery store, they're sitting on the bus. Those are all the sources of where someone might have gotten COVID. So we have a decision tree. If you haven't developed an ability and a procedure for evaluating work-relatedness, we're happy to share that with you on how to do that. In terms of citations, outside of those standards, we've seen general duty clause, we've seen record keeping, and we've seen respiratory protection. We've also seen personal protective equipment citations where they've said people have been donning inappropriate or insufficient personal protective equipment when exposed to active COVID individuals. And those tend to be more focused in the healthcare industry. All right, so in terms of citations, generally are relatively low dollar figures. You see a lot of $12,000 set of citations, but they may have a much bigger impact for employers from a public relations standpoint because it's all publicly available information. OSHA has an establishment search. If your company is, Adam Young's warehouse, someone could go and look that up on OSHA's establishment search and see that you've gotten 4 general duty clause citations related to COVID-19. OSHA releases press releases in which they often go after employers and said, well, this death of this individual could have been prevented if they had had better precautions and protocols in their workplace. So those can be very damaging. And then finally, with COVID, they've been putting out big lists of, these are the 300 employers we cited last month for COVID-19 violations. So there's all these different avenues in which they can publicly shame employers. And that's been a real effort in both the Obama, OSHA, and then now again with Biden to bring back a lot of press releases. And because they have such a small workforce relative to the size of the industries that they regulate, they try to use press releases to expand their reach and expand the impact of what they're doing. All right, so OSHA's guidance does not say employers have to mandate vaccination in any way, shape, or form. It's been guidance that's been up there for more than a year now, but it addresses vaccination in a lot of different ways that are important for employers to understand and to track. Vaccination, as I said, was the primary goal of the ETS and of the Biden administration's overall program to address COVID-19. So it's not surprising that the number one of their 15 points of guidance on OSHA's website is to facilitate employee vaccinations, to encourage employees, to train employees, to coach them on the benefits and ease of being able to get vaccines, OSHA even encourages employers to grant paid time off for employees to get vaccinated and recover from any side effects or detrimental effects from that vaccine. So there's encouragement of vaccination, and then there's some differential treatment based on whether someone's vaccinated or unvaccinated that OSHA encourages in its guidance. And that's quarantining for unvaccinated employees. They have been tracking the CDC's guidance. There's updated guidance on quarantine and isolation times. Quarantine meaning someone who's exposed, isolation meaning someone who actually has COVID themselves. And those are different based on the vaccinated status of the individuals. Physical distancing they recommend for unvaccinated individuals. Masking is recommended indoors. Or high transmission, which I believe right now is every county in the United States. There's also, a caveat there. If it's not an area of substantial or high transmission, they recommend it for unvaccinated individuals. As I said before, they recommend training on vaccination, and they also recommend suggesting or requiring that unvaccinated visitors wear masks. So a lot of employers are asking, well, what can we do? What do we have to do? Throughout the pandemic, we've discussed, 3 major tools to address COVID-19, reduce the risk of transmission, and reduce the associated legal liabilities. Because vaccination is really the top tool to reduce the chance that someone gets seriously ill at your workplace with COVID, form of vaccine verification is very effective. And these are all different options in complying with, and trying to attempt to get people vaccinated and determine if they have been vaccinated. A hard mandate is obviously the most onerous for employees. They have to get vaccinated unless they have one of those disability or religious exemptions. Our clients in white-collar type professions have been much more likely to advocate and push hard mandates, and they've been successful in doing so. The National Safety Council has found that companies with hard mandates have vaccination percentages more than 20% higher than if they don't have the policies. So they've been effective in the sense of getting more people vaccinated. And anecdotally, what we hear a lot from employers that they're hearing from employees that they were very happy to have been told that they had to get a vaccination. And I was very surprised to hear that type of response, because you would think people who didn't get vaccinated would not want to be told otherwise. But some individuals appreciated the employer making a choice for them in that regard. So it's a really unique experience and feedback we're getting from a lot of companies that's positive. But that's only one option, right? Other clients are going with surveillance testing for unvaccinated employees. Some are asking for documentation. Others are checking cards. Some are maintaining a roster like was required under the OSHA ETS. And then others are using some type of honor system saying, well, you have to be vaccinated if you want to work unmasked at this work site. But they're not checking anything to enforce that. Wellness screenings are a great tool to reduce the probability that an individual is contagious and at the work site because they're not symptomatic. And there's options there too, having management directed wellness screenings, encouraging employees to self-screen, or just training them on when they should be isolating themselves. And then finally, visitor policies. Those visitors are just as likely to have COVID-19 as someone who works at your office, and they may not be subject to any of the same protocols that you have. So that's the third major tool, having those policies that address who can come in the work site, whether they have to mask, whether they are required to stay to certain areas, and things of that nature. All right, and then going forward, as I said, we're going to expect to see a lot more complaints and whistleblower claims related to COVID-19. At one point during the pandemic, area offices were telling us they were getting 10 times the numbers of whistleblower complaints that they normally do. So numbers are way up, and those are all things that employers are going to have to be addressing going forward. All right, and I'll turn things over to our next speaker.
Thank you, Adam. I appreciate it. Although after that, I don't know that I want to go next because it sounds like, things are kind of treacherous out there. But in terms of the CMS regulation, as Scott mentioned, like the OSHA ETS, it had an interesting sort of path, if you will. And ultimately, as Scott noted, it is in effect. And of course, with everything that has gone on with COVID, nothing can be simple. We've got multiple deadlines and due dates depending on which state you are in. We have a number of, open questions that have not yet been addressed, but we'll do our best to address those as best as we can here today. And of course, certainly, some of the things that we're seeing with respect to, vaccination mandates, like Adam has mentioned, right? We are seeing some of the positive effects, even in the healthcare institutions, et cetera. But briefly, the CMS mandate, high level healthcare facilities, were instructed to have a vaccination policy by December 6, 2021. And healthcare employees were originally required to be vaccinated by January 4th, 2022. Some healthcare employers move forward with that regardless of the stay. Some healthcare employers move forward with that because they knew that it wasn't going to necessarily apply to them, the stay, et cetera. Ultimately, at the end of the day, as Scott mentioned, the CMS is now in effect in all 50 states. So what does that mean for all of you? Well, for those that did not challenge the CMS, meaning those states, guess what? Today, of all days, is the phase 1 deadline that I will be talking about here in a moment. So lucky you, you're at this presentation on the phase 1 deadline. What jurisdictions fall there? Well, besides the District of Columbia, you've got California, Colorado, Connecticut, Delaware, Florida, Hawaii, Illinois, Maine, Maryland, Massachusetts, Michigan, Nevada, New Jersey, New Mexico, New York, North Carolina, Oregon, Pennsylvania, Rhode Island, Tennessee, Vermont, Virginia, Washington, Wisconsin. If you didn't hear your state, please don't get too excited because I've got another whole phase and set of dates and deadlines coming up for you. But at this point, these are the jurisdictions where phase 1, the deadline is today, and the phase 2 deadline is February 28th. By the way, if you want to find these lists of states and didn't want to have to listen to my fast talking and listing of all of the states, there are FAQs on the CMS website that breaks this down for you. They're actually quite good, and I strongly recommend employers take a look at them as you're trying to navigate the CMS going forward. Who is in the next grouping of states? Well, that's the February 14th deadline. And really what, is there is all of the states that had challenged the CMS regulation. Texas, of course, as Scott mentioned, had to be separate and different because why have 2 deadlines? Why not have 3? And so Texas, their phase 1 deadline is February 22nd, 2022. So what do these deadlines mean, or what does this mean? Well, first, briefly, let me talk about who's covered by the CMS, right? So it's Medicare and Medicaid certified providers and supplier types. Think really broadly. There is general guidance on the CMS site, and then there is guidance by the different types of entities covered, such as ambulatory surgery centers, community mental health centers, outpatient rehabilitation facilities, home infusion therapy, hospice, and I can go on and on. Think broadly. And when you look, there is some individual guidance for these different entities. Additionally, what staff is covered? Well, it's all current staff as well as any new hires. So the CMS is going to impact existing employees as well as new employees. And we know for the healthcare system right now, they are certainly being stretched very thin in terms of their staffing. And so this could, present a challenge for many, but regardless of that, the CMS Reg is clear that it's all current staff as well as new staff who provide any care, treatment, or other services for the facility or its patients. It's a pretty broad definition. It can include individuals, right, who also, by the way, provide these services under a contract or other arrangements. So this gets into temporary personnel, contract personnel, vendors, you name it. So again, you want to be thinking broadly in terms of this. So what's the two deadlines and what do those matter? So the first phase 1 deadline, what that means is all staff have to get their first dose of a 2-dose vaccine by that date. That's really what it means in essence. And then the phase 2 deadline date is the eligible staff, covered staff, have to get the second shot by that deadline. That's how the CMS set this up. Under the CMS, just like what we saw with the Osha ETS, you do need to get proof of the vaccine. Some examples of proof that you can do are very comparable to what you're already probably familiar with from all the coverage of the Osha ETS. It can be the vaccine card or a legible photo of the card. It could be documentation of the vaccine from a healthcare provider who's provided a note certifying and clarifying that they've gotten that. It could be an electronic health record, or it can be a state immunization record. Some call outs related to the CMS that I wanted to point out. Unlike the Osha ETS, the CMS regulation has never had a testing alternative, right? So, Osha ETS was called, vax or test, right? Sometimes people use that terminology in terms of describing it. That is not the CMS. The CMS made very clear that this is a hard mandate for purposes of vaccinations. However, the question that has come up, though, is testing going to be required if accommodations are provided to qualified individuals under the CMS? So just like we've seen in various other contexts, yes, the CMS vaccine mandate is a hard mandate, meaning there is no choice. However, if someone has a sincerely held religious belief that conflicts with that vaccine mandate, or has a disability as covered under the ADA, it may provide an accommodation to individuals with respect to the vaccine mandate under the CMS regulation. Now, it's interesting, the CMS FAQs, again, which I recommend all of you take a look at, make very, very clear that they view these exemptions very narrowly. There must have been at least 2 or 3 questions that they included that said it must be absolutely necessary and supported. So we strongly recommend employers covered by this regulation follow your normal accommodations processes, meaning showing that you are getting appropriate information from the individuals, you are verifying the need for the accommodation, you're engaging in that interactive process, you're taking the time to ensure that accommodations are being requested properly and granted properly. I think what the FAQs were trying to do was discourage employers from just granting accommodations for the sake of just granting accommodations. There's not been a tremendous amount of detail as to how CMS may or may not, for example, audit the accommodations process to determine whether someone acted appropriately or not, but there is general information about enforcement and what CMS will do in those FAQs. So in terms of will testing be automatically required for any accommodation purpose? Again, FAQs are not clear, but what the FAQs do say, and testing is a big piece of this, employers must ensure that they minimize the risk of transmission of COVID to at-risk individuals in any accommodations that they provide. And I can tell you in most cases, testing is one of those provisions with respect to accommodations. Very, very common. So while not 100% mandated by the CMS regulations, do know that I think you will expect to see that testing will be part of accommodations that are granted on a going forward basis. Additionally, CMS, like we heard from Adam, strongly encourages in circumstances where there are unvaccinated individuals, of course, preventative measures such as social distancing where appropriate and utilizing whatever PPE may be appropriate as well. So Certainly, for those covered by the CMS, you have lots going on right now in your workplaces and dealing with your staff. But hopefully, hopefully you've been in preparation mode for some of this. We also have resources. Feel free to reach out to your Seyfarth attorney for any resources in helping you comply with this regulation. So I want to talk for just a couple of minutes about state and local responses. Many of you, I probably could have done a whole presentation on all of the state laws, but Adam, and Scott would not have liked that. So I agreed to do one slide. So this is meant to be a high-level overview slide, but know there's lots of detail about different state laws and things that are out there. First, there are two types of laws that have been passed. One are what I would call the state or local vaccine mandates, right? So think of New York City and the mandate in New York City. There's then the group of state and local laws that are what I call the anti-mandate laws. And they ultimately have some sort of provision in their law that says, nope, can't mandate the vaccine, or if you mandate the vaccine, you have to give expanded accommodations beyond just religion and disability or whatever that may be. So I wanted to walk you through a few of these examples because it is really important, because as you can imagine, if you are a multi-state employer that wants to try and come up with an overall policy or program, it can be very challenging to do so because without the Osha ETS in effect, we lost our preemption argument to many of these state laws. And so now today, just like we are in many other cases like paid sick leave and family leave, where we find ourselves is having to navigate the patchwork of state and local laws to determine what do we do to comply. So what are some examples of some of these laws, just to give you a high level? So some laws provide broader accommodation request rights, like Kansas. Texas is another one. What you see in some of these jurisdictions is, in addition to religious and disability exemptions, people can bring a request for an exemption based on personal conscience or choice. Some of the laws are very particular about what individuals need to submit, meaning they have to submit a formal attestation or they have to submit a formal affidavit or something of that sort, but some don't. Some just say they have to state it. So it's important to be mindful of that. Some laws automatically require testing as an alternative. So people tease, can you mandate the vaccine in Florida? I'm like, sure, as long as you say you can test as an alternative. And people look at me and they're like, well, then how is that a mandate? I'm like, well, it's a soft mandate. It's not the hard mandate. And at the end of the day, it's an automatic, just like the Osha ETS was in Florida. Some laws, which create a lot of heartburn for employers, say you can't discriminate against someone on the basis of their vaccine status. Well, what does that mean? If I have health and safety regulations that I need to implement, if I have to demonstrate that I'm meeting all of my safety obligations and that general duty clause that Adam Young mentioned, how am I going to do that if I don't track certain information, or if I don't know certain information, or if I don't take certain actions based on someone's vaccine status? This has created a lot of consternation for employers in that regard. My favorite one is the one in Tennessee, which prohibits mandating the disclosure of one's vaccine status. So this gets super tricky, and absent an employer taking a hardline position that look to meet OSHA's expectations and to properly enforce our safety regulations, they're going to run the risk of someone trying to claim that they don't have to turn over their vaccine status. The other thing that makes this super duper hard for employers is there are so many different bills pending, and that's not unexpected. We expected that once the OSHA ETS ruling came out, we would start to see other states jump on the bandwagon and take a look at, either putting in their own vaccine mandate or, for example, putting in an anti-mandate law. Indiana is expected to pass something very soon. Illinois had a little bit of confusion. Illinois had a posting that says we're adopting the federal OSHA ETS standard in Illinois. And then they clarified once the OSHA ETS was the stay was reinstated by the Supreme Court, that really only applies to state employees and state employers. And by the way, we'll take a look at private employers at another time, potentially. So I say all this to say we do recognize that this is a hard landscape for all of you to navigate, because it's constantly changing. It's constantly evolving, as COVID has in so many other ways throughout the last 2 years. Having said that, though, we have resources available to help you navigate this and assist this. But my key takeaways would be, before moving forward with any type of program, whether it's mandating the vaccine, hard or soft, collecting documentation, masking, all of those things, always check your state and local laws in addition to any applicable federal regulations and laws that apply to you. We're going to continue to see a proliferation in this area. I believe now I get the dubious honor of reading you the CLE code. I know you're all sitting on the edges of your chairs or wherever you are today. Here we go. CLE code, S as in Seyfarth, S as in Shaw, 6771. I'm going to repeat it one more time because Adam Lasky will not be repeating it at the end of his presentation, so get this jotted down. S as in Seyfarth, S as in Shaw, 6771. Adam, take it away.
Thanks, Tracy. I won't be repeating it because I didn't write it down myself. So thank you, everybody. So I'm going to talk about the federal contractor mandate, which was the first of the mandates, and is actually the strictest of all the mandates, well, when it was in place. Unlike the ETS, there was no test out option, and unlike the CMS, there was coverage that went well beyond the people who are actually working at the federal facilities. But I'm going to run through a little bit of a refresher on how we got here today, and then talk about the status of the legal challenges and what's happening with the mandate and what to expect going forward. So back in August, and I'm going to caveat that if I get any of these dates partially wrong, Scott Hecker should definitely correct me because he's definitely an expert in this area as well. So back in August, before any of these mandates came about, the president announced that there was going to be a vaccine or test program for all federal employees and federal contractor employees at federal facilities. Although what was a federal facility was really ambiguous in that. Basically, the president directed each agency to establish a testing program. And there was some lack of clarity at the time as to whether contractors would be able to use the agency-established testing programs or would have to go out and get their own testing program set up for their own employees who weren't vaccinated. That didn't last very long. So on September 9th, I think actually before any of that had been even fully implemented, the president issued executive orders 14042 and 14043. We're not really going to talk about 43, but that is the one that pertains to federal employees. Hard vaccine mandate for federal employees absent an accommodation for medical or religious reasons. It so happens there is a recent injunction on that one too by a federal court in Texas. Again, only applicable to federal employees. That mandate has been in place for some time and the deadlines to comply have long passed. So I don't know if there's, the injunction is a little bit too late in some ways, and the federal government has really spouted out a lot of statistics that mandate they put in under 43 sort of did its job already in their view. But anyways, Executive Order 14042 directed the FAR Council and the Safer Federal Workforce Task Force, we'll just call it the task force, and federal executive agencies to establish and implement a vaccine mandate and masking and distancing requirements, amongst other things, for certain enumerated types of federal contracts and federal contractors along certain guidelines established in the executive order. Well, it didn't end up looking exactly like what a lot of people thought from the executive order. So first what happened after that is the task force drafted its rules, its guidance as to what contractors would have to follow but the guidance itself wasn't a contractual mechanism to implement the mandate. It basically said, if the mandate applies through a contract clause, which is coming, this is what you have to comply with. And the easiest way to understand what the task force said is to try to think of the mandate itself as a virus, and think of the spread of a virus. And essentially, if there was some sort of contact, then the virus, or in this case the mandate, would spread to another set of employees in your company. So the main people covered were covered contractor employees, which was people working on the contract at issue, both people at the federal site and not at the federal site, and then any building that those people were working in. And I'm kind of simplifying a little bit this because it gets a little bit broader in some circumstances, but any building that they were working in that was essentially a covered, owned, I believe, or operated by the covered employer or its affiliate, would then become a covered contractor workplace, and then everybody in that building who was employed by that company would also be covered, even if they had absolutely no tie whatsoever to the federal contract being performed through this coverage in the first place. And then again, it didn't just apply to people working directly on the contract, but also it applied to people who were providing indirect overhead type support related to the contract, like HR and legal. And then anybody, essentially, if those people were working in a building, that building itself became a covered contractor workplace, and then anybody in that building with the same employer would then be covered. So it was pretty expansive. Like I said, the best way to think about it is sort of a spread of a virus. The task force, while it really wasn't within their scope or their power, also urged essentially for contracting officers to expand the scope of the clause, or where the clause would be included into contracts, to contracts beyond those that had been specified in the executive order. So for example, the executive order had basically excluded supply contracts and contracts underneath the simplified acquisition threshold dollar value from being covered. And the task force sort of said, well, contractors, officers, you should have discretion to include the clause even in those situations. So then the FAR Council issued guidance to agencies on issuing class deviations, and the agencies themselves issued class deviations to essentially create this deviation contract clause that specified that if the clause was included in the contract or subcontract, then that contractor or subcontractor was now bound by the task force's vaccine mandate guidance, essentially. And it also kind of described when that clause would need to be flowed down from a contractor to a subcontractor. And again, the FAR Council guidance was broader than what the executive order itself allowed. And on top of that, a number of the agencies themselves created their own guidance, and they were all many of them were there were very few that were the same. They were all over the board. Some agencies had much broader scope of when the clause would be included in contracts. Others were much more narrow. Some issued frequently asked questions to direct contracting officers to do this or that directly conflicted with another agencies. So it sort of created quite a bit of chaos. And again, the thing to remember about this was that the executive order was really a direction to government. It wasn't a law on its own for contractors to comply with. The contractors only needed to comply with this if the clause got into their contract or subcontract, at which point the task force guidance became the mandate law, I guess you would say, and that was what a contractor had to comply with. So this all got started to roll out in the fall. I believe the original deadline, if I recall, for compliance was December. And in November, the federal government pushed that back to January, right about the time the ETS was, I think, issued, and also sort of made it so that compliance became a little more wishy-washy, and sort of allowed for some degree of good faith compliance. So this was all moving forward until the court in Kentucky issued the first injunction. So let's talk about that. So there are currently 5 injunctions in place. that preclude the enforcement of the vaccine. We'll call it the contractor vaccine mandate. So there's the Southern District of Georgia, which was actually the second court, but it's the only court that. We're going to talk a little bit later about the scope of that injunction. The first court to issue an injunction was the Kentucky court. It's really a hard decision to understand, and I wouldn't recommend putting a lot of time trying to read it if you're interested in it. The second one was Georgia. I believe that Louisiana came third. Louisiana's injunction is extremely limited. It only applies to contracts between the 3 states that were plaintiffs and the government. It doesn't apply to contractors in those states necessarily, but the contractors in those states are covered by the nationwide injunction. And then Missouri and Florida came next. So again, those, all but the Georgia one, are all these other ones, they're just limited to very limited geographic scope. The Georgia one is the only national one. Appeals are now pending. The government has appealed 4 of the 5 of these injunctions. I imagine they'll eventually appeal the Florida injunction. We originally thought that these appeals would get expedited and move pretty quickly to the Supreme Court, just as the CMS injunction had. That is not happening. The 6th Circuit and the 11th Circuit are the ones where things have been progressing, but neither circuit has been willing to expedite these cases. And I think the earliest we can expect a decision from either of those circuits is March or April. And the other 2 courts were the appellate courts, the 5th and the 8th, it was only recently filed. So there hasn't been not a lot to report there yet. So we're not looking at anything imminent. It's, eventually this may get to the Supreme Court, but unless the federal government can find a way to get it through from another circuit, they're kind of stuck right now. So once these injunctions were issued, we're going to look at 3 things that have stopped essentially where the federal government has taken those injunctions and interpreted them and said, this is how we're going to apply them, and not enforcing this in the mandate in the interim. So the 2 things I have on this screen are both the Gsa Guidance and the Dod Guidance. Then GSA is not the only civilian agency, but it's a bellwether for civilian agencies. So I'm kind of using this as an example. And then Dod is huge. So GSA basically said we're not going to enforce the requirements to the extent it's in contracts, and they specified essentially 3 requirements that this mandate has: the vaccination piece, the masking and physical distancing, and then basically having a coordinator for compliance. Those are the 3 core requirements. And basically said that if contractors don't sign amendments that have the mandate, they will still remain eligible to continue to perform those contracts and for new contracts. DoD's deviation revision, their guidance to their contract officers, a little more specific. Basically, don't include the clause in new contracts, don't include the clause in new solicitations, and don't enforce it in anything that exists already, where the clause is already there. Now, what's kind of important is that is not the guidance that we started with the first injunction. When the first injunction came out for Kentucky, Ohio, and Tennessee, it only restricted application to those 3. Not actually tell the government they couldn't continue to include the clause, just basically said, you can include the clause as long as you specify you're not going to enforce it in those 3 states. And the task force guidance has also come out basically saying along those lines, if the clause is in the contract, it's not going to be enforced to the extent there's an injunction precluding its enforcement, either in a geographic range or in type of enforcement. So interestingly, in January, the federal government in the Georgia case, which is the one with a nationwide injunction, sought clarification of the Georgia court order as to what was being enjoined. The Georgia court denied their request for clarification, but at the same time clarified the order. Basically said, it's obvious what we were enjoining, it's a single judge. It's obvious what I'm enjoining. I'm enjoining the vaccine mandate. And he basically explained that the parties didn't really address the other parts of the mandate, the masking and the coordinator part and the physical distancing weren't really addressed in the briefing, and so his order was essentially just based on the thing that was being addressed. And this could have some pretty substantial significance, which we're going to talk about in a bit. Hopefully it doesn't, but it could. So what comes next? So there is a possibility, the door has been opened for the federal government to now change its guidance again on implementing this EO, the executive order as a whole. There is limited geographic injunctions that cover just certain states for the entirety of the executive order, whereas there are the only national injunction now clearly only covers the vaccine mandate piece. Nevertheless, the major agencies have still decided they're not going to enforce the entirety as of now. Their guidance, and I would say the thing to look for first is GSA and DOD, especially DOD, because its current guidance is very specific to contracting officers. If they change their guidance, what they would essentially be able to do is say you can start including the clause again in contracts that are not tied to the states that are covered by those other injunctions. And the task force guidance already precludes enforcement of any element of the mandate that's covered by the vaccine mandate basically would be precluded. So essentially, if the government wants, they can start inserting the clause again in some contracts, and they can also start enforcing immediately the physical distancing and masking requirements, which again don't just apply to the federal facility itself, but would also apply to other buildings where a contractor had cover contractor employees in them. So hopefully they won't create this chaos, but it is possible. And one of the side effects of this is that currently contractors are essentially in a position where they can compete for work without really assessing, can we really comply with this mandate if the injunctions are lifted. But if the clauses start getting inserted again, you're going to then the contractor essentially has to take a clause, and that clause becomes dormant as to the vaccine piece. And if the courts eventually rule in favor of the government and say that the vaccine mandate part is allowable again, then now you have a mandate already in your contract, and there's not really any way to get out of it. So that is a major significant piece of this. Now, going next to the part, well, what will happen? Well, what can we read anything in? If this gets to the Supreme Court, can we read anything from what's happened with the ETS and the CMS decisions? I would say that essentially there's two challenges. The primary challenges to the vaccine mandate are it's beyond the scope of the president's powers on the Federal Property Act, and the second is that it's essentially violation of states' rights under the 10th Amendment. There have actually, even of all the courts that actually cited and enjoined the amendment or the injunction, they haven't all agreed as to why it should be enjoined. And there's at least one court that said it was not beyond the Federal Property Act. I believe it was the Louisiana court, although it said there was a significant nexus at least. And then there's another court, the Missouri court, that said it wasn't a violation of the 10th Amendment. So that kind of leaves some degree of possibility that this could succeed, the government could still succeed. But at the same time, when you look at the ETS and the CMS decisions for the Supreme Court, it doesn't look very good for this mandate either. The policy behind the mandate in comparison to the policy statement for the other mandates is puny. It's a single paragraph compared to over 50 pages in the CMS mandate as to why that was necessary. The statute that this is being done under the Federal Property Act has never, according to these other courts, their position has never been used in this context, and it's the scope of this mandate is actually much broader than the CMS. I believe the numbers I've heard on the CMS mandate is it affects maybe 10 million people, and somebody could correct me if I've got that wrong. The numbers projections on the contractor mandate is that it could cover as much as 1/5 the workforce of the United States. So the odds are not looking good based on those decisions, but at the same time, I think if the government wants, they could go back and narrow the scope of this mandate, and they would probably have a much better chance of succeeding. And so the door is not completely closed on this. One thing, though, to keep in mind is the vaccine and testing requirements for federal facilities are being rolled out. And so essentially, if you have employees at federal facilities, they are essentially going to be covered by comparable requirements to the ETS as if it still existed. And that's basically a vaccine proof or testing within 72 hours of your entry onto the federal facility. And that is not being enjoined by these court decisions. And on top of that, I don't even believe it's being challenged. I haven't seen anything that's challenging it. And again, also, if there are any state or local vaccine mandates, they are not impacted by the decisions on the federal contractor mandate. Lastly, and I know we're a little running out of or almost out of time, what should you do in the interim? I think the most important thing to get ahead of this is kind of keep your ducks in a row in case this does come back. And one thing to consider is there are some situations where you can really mitigate the spread of this mandate if it comes back in its current form. There are a lot of ways you can use affiliates to the spread of the mandate. There are ways to move around overhead to limit the spread of the mandate. There are ways to not classify things as actually sub. There are a lot of different strategies you can take, but some of them aren't going to be things you can implement overnight. And so the things to look at is, where can I start to get ahead of this and create strategies that will help me mitigate the spread of the mandate should it come back, if that is going to be a major business problem for my company. And also, I think the other thing is be prepared, because the government could flip the switch at any point and change its guidance based on this Georgia quasi-clarification, and all of a sudden allow contractor, or allow the government to start inserting this clause again, just with more limited application. So that is all I have, Scott.
Thanks, Adam Lasky, Adam Young, and Tracy Billows. Really appreciate your insights today. Thanks again to everyone who was able to join us. We know a lot of information was presented, and if your specific question didn't get answered or more come up, please feel free to reach out to any one of us or your favorite Seyfarth attorney, and we will counsel you in the right direction. Thanks so much, and have a good day.
Thank you. This concludes today's webinar. Thank you for attending.